अऊज़ु बिल्लाहि मिनश शैतानिर रजीम बिस्मिल्लाहिर रहमानिर रहीम नहमदुहु व नुसल्ली अला रसूलिल करीम. Last time we had discussed leave a legacy. While discussing the subject leave a legacy, we had in the second lecture we had discussed certain ayat, and in that ayat particularly, in this ayat particularly 433, we had seen that the term mawali we have not properly uh, perhaps we have not properly understood it, and we have not created an institution of mawali which can deal with the matters of inheritance, wasiyat, and generally speaking tarka. And we have also not developed a concept which has in fact created an idea of legacy, leave a legacy. Legacy covers all these things: inheritance, wasiyat, tarka. And when we define it as a legacy, then we find that just development of the concept of legacy in the West, it has revolutionized and it has developed so many other institutions. For example, philanthropy, health, in health, education particularly, we see a lot of memorial hospitals, educational institutions, universities, because people leave their tarka, they leave their inheritance, they leave their wasiyat as a legacy. We have not developed this concept. Because of not developing this concept, we have generally left this entire matter to the person who is the strongest in the family, who has the vested interest, who takes over not only his own share, but he takes the lion's share, and not only the lion's share, the best share, and not only the best share, but in fact, he takes over shares of other weaker members of the family, like mother, daughter, sister, and other persons, just because of that. And on one hand, we have not developed the concept of mawali. We have not split it into offices, and we have not developed the concept of legacy. And then we have uh, uh, not developed a framework, a legal system, administration, and so many other related organs of the state which duly supported, which in the developed society they are available as a support. And in this concept, in this context, we had also seen that we have also not defined and not included as a part of the institution, Wallazeen Akadat Aymanukum. Today, I will try to discuss all these matters with reference to the present system, particularly in America, and generally speaking in the Western world, how they have created these institutions and how they deal with them. Although we have all these laws in Quran, and along with this, there is another responsibility that it just doesn't say that you distribute, it says for atuhum, deliver, deliver the shares so that they don't have to run about. Here we have seen old mothers, widow sisters, widow daughters running about in the courts and in certain offices. Although Allah subhanahu wa ta'ala had warned that I am shaheed over it, everything I'm watching, He is watching internally, not just outside as a shahid, but He's watching internally. And I had brought these ayat also just for your consideration. But today we are going to discuss the legal system, these systems in the West. But this is just for recapitulation. I had also pointed out that in one ayat, where the parents of the, say, an orphan are not known, and he is declared as the brother in the deen. But the Quran has also declared him, or declared that person as Mawali. So what does that mean? If he becomes Mawali, as defined here, if he becomes Mawali, as defined in these ayat, then it means it has certain rights and responsibilities. But generally, in our jurisprudence, we say that the adopted person doesn't have any right to adopt, the right to inherit. But here, same word Mawali has been used. I leave it to your consideration. We are not going into these finer questions of jurisprudence, but then after discussing the role of a Mawali, we had in fact reached the stage where we had come to discuss the system in the West. So today we will discuss the system in the West. Before we take up that discussion, last time I had also referred to this terminology. There were different terminologies. One of the terms was executor. Executor is also one of the aspects of duties, responsibilities, rights of the Mawali. Here in the West, they have segregated, separated each role under a separate designation, under a separate office, under a separate law. And those laws deal with that. So, executor, representative, administrator, these are just different aspects or offices or responsibilities of the same person, as you say, Mawali. But according to Quran, Mawali is the inheritor also. So the inheritor as Mawali has the certain rights and he has certain responsibilities also, which here we find have been separated in the Western law, in the Western system. In order to deal with the entire matter of inheritance, they have created a legal system, and the process is called probate. It is not left to the person who has a vested interest in the family, who is the strongest in the family. It has not been left to him to take over the property or distribute the property or administer the property or execute the property or execute the title. He can't do anything, nothing. All the process, entire process is known as probate. And probate is decided by the court. It has the legal authority. It is not decided by even by the executor who has been mentioned in the will. So the probate is not decided by the interested person who has any interest in the share, who is a sharer. It is not decided by the executor himself. It is not decided by the representative himself. And it is not decided by the administrator himself. The process called probate, this process, which is called probate, it decides. And it is decided by the court. So, what is probate? Probate is a legal and financial process. Unfortunately, in the entire Muslim world, in our families, in Muslim families, this process, which is called probate, which is legal and financial process, is not taking place. That is why the actual purpose of inheritance, which is a very important uh, uh, segment of the economy, I'm repeating, of the economic system, of the economic system of Islam. It is a very important element of economic system of Islam that has failed because probate is not taking place. Probate is a legal and financial process of dealing with property, money, holdings, and possessions. These are different things. One may possess a thing, but he may not hold it. One may hold a thing, one may not possess it. But in general terms, what we say, instead of that, we say dealing with the property, money, and anything owned, holdings and possessions owned by the deceased of the person who is dying. But when we come to discuss in detail, we'll find that what is the meaning of holdings, possessions, ownership, money, property, these are subject of the probate. A will is a legal document. Will is not just a religious document. It is a legal document. We have made everything just religious. Religion has two aspects. One is secular, and the other is which pertains to theocracy, to theology or the divine. But we have mixed up the divine and the theology part with the secular. So will is basically under the divine ordainment, under the divine ordainment, prepared under the divine ordainment, it becomes secular. Every act in according to Islam we do is ibadat. It is covered under the divine ordainment. So it is ibadat. But for example, in that ibadat, we are taking food, we are earning. This is secular, worldly matter. We are growing food, we are selling food, we are selling in the market. These are secular things. So we have mixed up, misunderstood the secular and the religious components of Islam. So will is a legal document, and in this respect, it is secular document also. Prepared under the divine ordainment of Allah subhanahu wa ta'ala, it is then implemented as a secular document. Probate is what is probate? What is the purpose of this process? It is the official process of proving the will. First of all, when the matter is referred to the court, the first thing the court has to do is to prove the will. Will is written by the person. Will is dictated by the person who has died. This has to be established. There is one will, it is called self-witnessed will. For example, if the person has written a will in his own hand, then it may not require any attestation. It may not require any notary. It may not require any other process. On the face of it, the court can say the will is proved because it is self-witnessed, self-written will by the deceased himself, if it is proved. So the first thing is the official proving of the will. Then number two is, in fact, this is the same thing, but it is something making it more clear to establish the validity of the will. Well, how it becomes valid? First, it is written by the person himself. He owned the property. He has not made a will of the property which he did not own, for example, or he has made a will which is more than 1/3 of the prescribed portion of the property which he can subject to will. So these things are covered under the validity. The first thing is to prove the will. Then the next is to establish the validity of the will. So these two things are proved and validated in the process of probate, and process of probate is conducted, is done by the court, not by the interested party, not by anybody in the family. Probate, what is probate? These two things which you have said, it is in fact the process of analysis, analyzing, auditing the will. It is a process of analysis, and the most important part then comes, that is the transfer of administration. Now, once the probate is done, the administration of the property of the deceased, which is subject to will, that portion which is subject to will, or other than that, another portion, the other part also, once the probate is done, the administration of that property, of that estate, sorry, it is called estate. After the analysis, after proving it, after validity, then the next thing is to transfer the administration. Transfer the administration to whom? To transfer the administration to the executor, the mawali, he, to the representative, to the administrator. Then it is the duty of the executor or the administrator or the representative to transfer the title, to transfer the title of the estate of that property which has come for probate to the beneficiaries, which was previously owned. This is the here we have used the word owned. Here we are not saying possessed. We are not saying holding. Holding has a different economic meaning. Possession has a different economic meaning. And here the word is used technically, legally owned, which is previously owned by the deceased, which is called estate asset. Now that has been proved, that has been validated, that has been analyzed, and now the executor has been authorized to transfer its administration and transfer the title. Estate assets are reviewed by estate assets, anything becoming part of the estate asset. Estate assets are reviewed by probate court. I'm emphasizing right from the beginning, it is the matter of the court giving final ruling. The ruling of the court is final on division and distribution. These two things. It's not just division. They just don't leave the process at division. They divide, they describe the shares, and then they order for the transfer, for the distribution to the beneficiaries. To the beneficiaries. This is most important part, and this is, as I've seen in my experience, this is the most difficult part of it. Even when the decision is given by the court, the probate is given, people who are going to implement it and who are the interested party, they try to create a lot of legal and other problems. So this is also very important, the distribution, the actual distribution, so that the actual right reaches the beneficiary, so that the beneficiary receives the actual right. Probate is legal process to distribute person's property. I'm summing up. To distribute person's property, which is called estate, owned at the time or at the point, at the start of death. Before death, there's no inheritance. The inheritance opens at the time of death. In many cases, in majority of cases, rather I may say that in overwhelming majority of cases, children force and even wives, they force their husbands, the children force their their parents to give them the property while they're alive. Inheritance means something which comes for probate only after, at the time and after death, not before that. No sibling, no parent, no children, no wife can praise anybody for their share which they otherwise feel that they have in the property they will inherit. They may not inherit. By that time, when the person dies, the situation may change. The quantities may change, the amounts may change, the relationships may change. Therefore, it opens only at the time of death, and there is a wisdom. And as a precautionary note, if you allow me, I may submit not only on the basis of what I have read, not only on the basis of what I have experienced during counseling sessions in Maryam Masjid, and not only on the basis of my experience in the court, but otherwise also what I have seen in the society. I may leave a precautionary note, a cautionary note, a caution that kindly don't distribute any of your property to your inheritors, which you think they are going to be the inheritors, till let me say for myself, till I'm dead and gone. Allah subhanahu wa ta'ala has prescribed this system. And I have seen that whosoever has done this during the lifetime, it has consequences. And there are bad consequences. And those people who do this, they face a lot of difficulties. So kindly, this is my request, my advice. You may ignore it. You may have different experience. That I'm telling you, submitting on the basis of my experience, that kindly don't go against the will of God, who has himself given this ordainment. It is a divine ordainment that the inheritance, the will, the tarka will open only and only after my death, not before that. Before title may be transferred, all these processes are to be completed. The title company cannot transfer the title till the proceedings of the probate are brought before them. But in our countries, in Muslim countries, since no probate is taking place, the titles are being transferred without probate. Getting a heirship certificate or a succession certificate is a different thing. Like probate is a much deeper, much detailed thing. Probate is the estate administration called probate process, which we have discussed, which is called probate also in small, in nutshell. Or this process is called probating the will. It refers to the process by which court determines that purported will, the document which is called will, which is supposed to be a will, is final. They prove not only the contents of the will, they also prove that this is the last will. It is the final will. It is the final testament. It is the last will. Somebody may have made a will 2 times, 3 times, 4 times, but then we have to segregate and we have to find out what is the last will, what is the final will, and as a will, it is really the testament of the person who has made this testament as a will. And it is legally valid to pass the title of the property which was owned by the deceased. And the court in this process now is called granting the probate. Granting the probate. Once this probate is granted, it is granted to the executor. The executor is the one who is usually mentioned in the will, that for the purposes of this will, so and so will be the executor. If the executor is not mentioned in the will, then the court can appoint an administrator. But if the executor is mentioned in the will, then court officially, legally authorizes the executor mentioned in the will that now, according to the court decision, now according to the probate of the will, now you have to proceed to distribute the property and transfer the title. This is the process, this is the procedure, but we don't know that. Usually we don't know that, and then the problems come up, and then the inheritors, they start fighting between themselves. Probated will then becomes legal instrument. These are legal terms. Legal document and legal instrument. Will is a legal document, I said in the beginning, but now it's a legal instrument. Instrument, for example, key is an instrument. You apply the key to the car and it ignites and it moves. So when this legal document is transformed into a legal instrument, it becomes mechanical, it becomes kinetic. It is a legal instrument that may be enforced by the executor, because now the executor is authorized by the court. Now he's acting on the power which has been given by the court. Before that, it was just a will, it was a wish of the deceased. But now it has the support of the power of the court, which is supported by the power of the state, which is supported by the sovereignty of the state. It is enforceable at law. While now this document cannot be refused by the title company, it has to be enforced. It has now the support of it has sovereign support. In the law court, it can be executed if necessary, whenever the need be. Probate also officially appoints executor, personal representative, generally named in the will. I've already said this, so I think there's no need to repeat it. I have already mentioned this. Now we are coming to the part which is not mentioned in the will. It is called non-probate assets. Here, when we are referring to will, let us be clear. Now we are discussing the Western system. If we are discussing Islamic system, there in our mind, the will pertains to only about 1/3 of the property. But in the Western system, when we are talking about the will, generally it covers the whole property. But there are cases where the will has not been made for all the property. There are certain assets which are not covered in the will. That part is called non-probate assets, which have to be passed on as it is, are transferred directly to the beneficiary, and are not subject to probate court proceedings because they are not included in the will. There can be situations. Therefore, this word is used, non-probate assets. In absence of legal will, now we are using here the legal will, because will is a legal document, legal will. Estate is settled according to laws of intestacy. In absence of legal will, when there is no legal will, one has not made a will, whether it is Islamic or if it is Western. If there is no legal will, the estate is settled according to laws of intestacy. When somebody has not left the will in the Western system, he has to make a will for the entire property, but he has not made the will. If that is the case, then there are laws which are called intestacy laws. For example, in Quran, there are laws for kalala. But here we are discussing the state or the condition when the testament or the will has not been made. Then rules of inheritance in the Western system, general rules of inheritance will apply. And in the legal system of Islam also. And it's the same thing at the time of death. What were the laws of inheritance at the time of death? They will apply. Laws of inheritance. Now, we are not talking only of the will. We are talking, because there's no will, we are talking of laws of inheritance. They will apply at the time of death. In cases of intestacy, when there is no will, inheritance proceeds according to specific hierarchy of beneficiaries. For example, in Islam also, there are sharers, the nearest and the farthest. The nearest eliminates the farthest. So here also, there is a hierarchy of beneficiaries, but the different terminology is used. For example, surviving spouse. But in this system here, there is a civil partner also who inherits. Civil partner, like a girlfriend, or anybody who has attained the status of civil partner under the law. even though she is or he is not a spouse in the legal sense, but he is a partner or she is a partner as a civil partner. He has attained that status as a civil partner. Then the property will be distributed among them. For example, in Islamic world, in some people follow, some sects follow, some sects don't follow. For example, muta, then they don't follow the laws of inheritance. These are not applicable. But here, even when somebody, for example, a spouse claims muta, and that determines the status as a civil partner, even though not a spouse, he or she will be entitled to be a party to the probate, can claim as a party, as a civil partner. Now, these take priority, and then followed by, after that, children, and after children, then parents, siblings of the deceased, and more distant relatives, kurba. These are the nearest ones. And then we see that the children, the category of akraba is defined differently here, and then kurba differently defined here, and then will come grandparents, aunts, and uncles. If no surviving family members are found, the estate may pass to the what we call rasat, to the estate. This is estate property. Let me put it into uh, inverted commas. This estate may pass to the estate, riyasat, not government. There's a difference between estate and government. It will pass to the estate, and this process is called escheats. If there are no surviving family members to inherit, then the property estate passes on to the state, and this process is called escheats. And this is also decided by the court. No individual can decide this. This also applies where will has been made only for part of estate. In the beginning, I said that although will has to be made for the entire property, but for example, somebody has made a partial will for the part of the property, and other part is not covered under the will, then this process will apply, which we have discussed. Intestacy laws. There are not only testacy laws, but there are intestacy laws where there is no will, where there is no testament. There are laws for that in testament, in intestacy state also. Intestacy laws are also referred as the laws of descent and distribution. For the executor, I have mentioned already. I think I leave it here because this will require a bit more discussion, because the cases which I have been dealing with here, people are usually not clear about who is executor. So we will discuss this concept inshallah next time. Subhana rabbika rabbil izzati amma yasifun. Salamun alal mursaleen. Walhamdulillahi rabbil alamin.
اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه. اللهم اهدنا فيمن هديت، وعافنا فيمن عافيت، وتولنا فيمن توليت، وبارك اللهم لنا فيما أعطيت، وقنا واصرف عنا شر ما قضيت، فإنك يا ربنا تقضي بالحق ولا يقضى عليك. اللهم ادخلنا برحمتك في عبادك الصالحين. اللهم اخرجنا من ظلمات الجهل والوهم إلى نور العلم. اللهم علمنا ما ينفعنا، وانفعنا بما علمتنا، وزدنا علما. اللهم اجعلنا ممن يستمعون القول فيتبعون أحسنه. اللهم اكفنا بحلالك عن حرامك، وبطاعتك عن معصيتك، وفضلك عن من سواك. اللهم فضلك ورحمتك على كلمة الحق والدين. اللهم انصر الإسلام وعز المسلمين يا أكرم الأكرمين. Oh Allah, spread your mercy upon us, shower us with your blessings, increase our knowledge, grant us forgiveness, and reward us with the company of the prophets in the Firdaus al-A'la. Oh Allah, forgive our parents and all our friends and relatives who have passed away. Oh Allah, make their graves a garden from heaven and grant them the Firdaus al-A'la. Oh Allah, we have many of our friends and relatives who are sick. Oh Allah, we have our son Ma'raj, our daughter Aisha Wani, and many others. Oh Allah, grant all of them full and speedy recovery. Oh Allah, guide our children, protect them, and make them righteous. Oh Allah, we seek from you all of the good, whether we know it or we don't. And we seek your refuge from all evil, whether we know it or we don't. Oh Allah, we have many of our brethren who are living under oppression and injustice. Oh Allah, heal their trauma, protect their helpless, and grant them lasting peace and prosperity. Oh Allah, we ask you every name you have elected for yourself, that none of us leave this gathering, but his pains have been relieved, his worries have been removed, his debts have been paid, his weaknesses have been concealed, his sins have been forgiven, and his needs have been fulfilled. Subhanallah wa bihamdih, عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. وآخر دعوانا أن الحمد لله رب العالمين والصلاة والسلام على خير المرسلين. اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه وسلم. والسلام عليكم ورحمة الله وبركاته.